afternoon, and thank you for joining us at I'm not sure if we're the first or one of the earlier of the Greenway Chambers CPDs, and the first one will be on trusts in family law, and it's described as not just Kennon and Spry, but there might be a fair bit of Kennon and Spry. So if there's false advertising, I take no responsibility because the topic was set many months ago last year before we started writing it. So if I could ask Leah, Reid to start.
Hi everyone. This particular topic is of increasing importance in family law, and that's because trusts as a vehicle are becoming increasingly common. The latest ATO data I could find was December last year. Trust business income of $390 billion in that financial year alone, 2019 financial year. Trust assets of over $3 trillion. And the number of discretionary trusts has more than doubled in the last 2 decades and a bit. So it's more than likely that you will be facing a case where one or both of the parties is a potential beneficiary to a trust, they have their own family trust, or there is some complex trust arrangement that you'll have to get across.
Can we start with some basic language and a reminder of the things that we've potentially forgotten since law school as to the criteria of trusts that is, I suppose, what we're talking about, and just because of the importance of definitions in this context, we might just start with the absolutely obvious propositions. So the first and most common kind of trust is obviously an express trust, obviously recorded in writing, usually in the form of a trust deed. But for present purposes, the main demarcation that we're talking about is between a fixed trust and a true discretionary trust. In a fixed trust, the important criteria is that the beneficiary's interest in the trust assets is defined by the deed or agreement by proportion or category. A common example or analogy might be a unit trust, although that is, I suppose, less common in this context. The most common kind of trust structure that seems to be causing difficulties or complexities and disputes in the family court context is true discretionary trusts. And by discretionary trust, we're talking about the object of the discretionary trust being a number of potential objects of a power being exercised. So a trustee would commonly nominate a number of persons or category of persons who may be the subject of a disposition of trust assets. So they're often described as not as a discretionary beneficiary, which suggests some interest of a beneficial or equitable kind in the assets in the trust, but simply as the object of a power or an eligible discretionary object. And two consequences flow from that a beneficiary has no specific rights in the trust assets. They are simply someone who has a right to be considered by the trustee, or what is described in many of the older cases and picked up more recently as a right to due administration of the trust, or a right to be considered, which is potentially meaningless in the obvious sense. The flip side of that is that the trustee has a fiduciary obligation to consider all discretionary objects and has potentially discretions in relation to powers of appointment, which is the other alternative side. And we'll be returning to those concepts when we come to consider Kennon and Spry and the other cases since it. We'll just mention the other categories that we're not dealing with in a sense, and the first is obviously resulting trusts, or what is sometimes described as an implied trust. The more common examples of a resulting or implied trust are usually a transfer of an asset or a payment into the name of another party to hold the beneficial interest on trust for the beneficiary. An obvious example is a parent who might provide money for the purchase of a matrimonial home or some other asset, and the question arises as to whether the provision of that money was a gift to the person absolutely, or with the intention that it would be held on trust for the parent. Important in that context are the rules as to the presumption of advancement that often implies in a family or matrimonial setting. We won't be dealing with those in any real detail in this discussion, because they don't really throw up the sorts of difficult questions of trust law and the family court's powers to go behind trust arrangements. The third kind of trust that you'll see referred to in the authorities is a constructive trust. It is more commonly relevant in the equitable context in the Supreme Court litigation in relation to property. It doesn't seem to be terribly relevant in a family law context because of the breadth of statutory powers in the Act, and in particular Part 8AA, which we will come to in more detail.
So usually for family lawyers, the key thing will be characterising a party's interest in a trust and whether it amounts to property, whether it amounts to a financial resource, or neither of those things. So for property, the relevant sections, of course, are Section 79 for married couples and Section 90 SM for de facto couples. And that provides that the court can alter a party's interest in property in proceedings with respect to property of the parties. That phrase is very important, and it's read in connection with the definition of property in Section 4. So Section 4 of the Act, property is defined in relation to parties to a marriage or in a de facto relationship as property to which the parties are entitled, or one of the parties is entitled, in possession or reversion. So the reason that this is such an interesting area of the law is that, as we'll see, there are various examples where the court would not be able to say that the assets of the trust are necessarily the property of the parties, but they could be something else. It could be that they are a financial resource. So again, if we're primarily going to be speaking today about property settlement cases, but of course if you're dealing with a spousal maintenance claim, then under Section 75 or 90 SF, the court has to consider, in addition to property and income, what a party's financial resources are. And a financial resource is a source of financial support reasonably expected, that the party reasonably expects to be available to supply a need or deficiency. Now that definition, of course, is not found in the Act, but that's what the High Court tells us it is. And of course, in property settlement proceedings, we still need to consider at the future needs step, that sort of third of the four hickey steps, the matters in Section 75 too. So in that regard, if a trust is a financial resource, the court can take it into account when considering a party's future needs. Or as you might see later on down the track, a trust could end up being nothing. It could be that a person is named as an object in a discretionary trust, but really they're not likely to get anything from it, in which case it wouldn't be either property or a financial resource.
And in one sense, you get the description that you'll see in the judgment in Kennon and Spry of Justices Gummo and Hayne, which describe the discretionary object or the beneficiary's interest in the due administration of the trust being an asset which can be adjusted for the purposes of Section 79. Now, that must, in a practical sense, seem far from an obvious benefit if the only right that you have is a right to be considered and a right to enforce the due administration of the trust. One also needs to consider, and this is what we'll come to, the way in which you would have the trust assets brought into the pool. So it's not, what one has the principal question of what parts of the trust assets can be treated as the property of the parties, but then in a sense how one brings them in. If all one is valuing is a right to have the due administration of the trust that one hasn't ever received any money from or may not receive a distribution from in the future, that may be a fairly Pyrrhic victory. The other interesting thing that we'll talk about, which seems to have been adverted to in a couple of the judgments, but not all, in Kennon and Spry, is the related power in Section 85A to make orders in relation to antenuptial and postnuptial settlements, whatever that might mean. It's not a concept or definition that is easy to grapple with, but we will come back to that because it does seem to be an unexplored resource for remedial aspects in some contexts. So if we then go to some common examples, the first obvious example is which we've set out there, where one of the parties to the marriage has what one might call, in the old-fashioned terms, an heiress with a large family wealth, and there is a trust. They are a potential beneficiary. The parents may give her some money in a discretionary family trust. She may have received money historically as income from the trust and have an expectation for the future. That has two aspects which we'll come to consider. In one sense, it is not likely to be, absent clear circumstances, a situation where the trust assets can be brought into the pool, because those assets are assets of the trustee from the parents and are not assets in the trust from the parties to the marriage. They may be more properly described as a financial resource, which is perhaps the other way to consider it.
And that would probably depend on how frequently the wife would be getting distributions, and whether or not she'd ever been loaned any money from the trust, for example. So those are relevant considerations which we'll come back to.
The second common example is where parties to the marriage have a family trust, usually set up for tax purposes or sometimes for asset preservation, where one of the parties to the marriage, and here the example selects the husband, is the appointer or settler of the trust. Usually the discretionary beneficiaries are the members of the family, the husband and wife and the children, and the husband, as the trustee and settlor, normally has powers to change the trustee, to make distributions to any of the intended beneficiaries or the nominated discretionary beneficiaries at their absolute and unfettered discretion. But none of the particular discretionary objects has an allocate proportion of the trust assets allocated to them. So, for example, if you have a trust with a whole series of assets, whether it's real property or shares or other assets, the trust deed would not say husband has X percent, wife has Y percent, or a designated proportion for the children. Now, that is, in one sense, very much the situation that was considered by the High Court in Kennon and Spry, which we'll come back to in a little bit more detail in a moment. Our third example is where you have a husband and wife with a family trust, although there is a corporate trustee. One of the parties to the marriage may have had a third party as a director of that corporate trustee. It's a common example one sees where, say, the husband or wife has a business, and that business includes a family member or an accountant or professional who has no interest in the business other than in a professional sense. So they are not deriving income from the business other than being paid their hourly rate as a professional, and they would, in the ordinary course, exercise their powers as a director of the trustee at the behest of the family member who appointed them. So in that context, one would readily see that the family member is in de jure but not legal control of the trustee, which is important for the context of determining whether the trust assets are beneficially owned by a party to the marriage. And our fourth example is perhaps the problem child, so to speak, where the trust has persons who are not part of the parties to the marriage or their children. So if one has a brother who is a director of the corporate trustee, the beneficiaries of the trust may extend more broadly into the extended family. One sees this sort of situation in wealthy families where a parent or grandparent may have started the trust, a large amount of assets have been accumulated in a family business. There is then a dispute and the family court has to try and determine whether the assets of the broader family trust can be treated as assets in the pool as property as defined to be the property of the parties to the marriage. And the difficulty in that situation is that the parties to the marriage are only ever discretionary objects, and no doubt their siblings, parents, grandchildren and the dog would also be discretionary beneficiaries, and none of those discretionary objects would have an allocate proportion of the trust. They would all rely on the trustee exercising a discretion to make distributions. So one could not say that a particular proportion of the trust assets relates to the parties to the marriage.
So I think that one of the things that you'll notice in some of those scenarios is that there's a varying amount of control that the parties or one of the parties to the marriage has. And control is a concept that we're going to come back to. But we might go back to Kennon and Spry and have a bit of a refresher about what the facts of this case were. Dr. Spry, a famous barrister down in Victoria, marries his wife, Mrs. Spry, in 1978. Now, before he gets married, he actually does create the family trust. But because he doesn't want to pay any stamp duty, he doesn't actually stamp the trust instrument until 1981. So that's when it's executed. So the 1981 trust instrument provides that Dr. Spry is the trustee and the settler, and the beneficiaries are the husband, his siblings, the spouses and their descendants. So the marriage is going along fine at this stage, and a couple of years after the trust instrument's signed, Dr. Spry decides to make some variations. One of the variations he makes is he excludes himself as a beneficiary, and he also appoints his wife, Mrs. Spry, as the trustee upon his death or resignation. Now, by 1998, their marriage is in trouble at this point, and a secret variation is made by Dr. Spry, which removes the husband and wife as capital beneficiaries. So at this stage, the wife is still an income beneficiary, and allegedly this instrument is irrevocable. We'll come back to that in a moment. Now, they finally break up in 2001, October, and quick smart, there's another change to the trust. So by January 2002, what Dr. Spry actually does is he creates 4 separate trusts, one for each of his daughters, and he applies to, in those trusts, the children's trusts, a quarter each of the capital of income of the main trust. Now, it's only 4 months later that the wife commences proceedings in the family court, and in particular, she commences proceedings under section 106B, which you'll remember is the section which is to set aside instruments that are likely to have the impact of defeating a party's claim or were entered into with the effect, or with the intent, I should say, of defeating a party's claim. So Justice Strickland was the trial judge, and he made a number of different findings in relation to why the husband had entered into these 2 documents, the 1998 instrument, that's the secret variation, and the 2002 instrument where he creates the 4 separate trusts. So in particular, the findings that Justice Strickland made was that he didn't tell the wife about the secret variation. It was at a time when their marriage was already in trouble, that the intended effect of that 1998 instrument was to remove Mrs. Spry as a capital beneficiary. And one of the things you have to understand at this stage, the trust includes the former matrimonial home that they're living in, worth quite a lot of money. And there was no agreement in relation to the 2002 change. There was no agreement between the parties that the children would get the assets of the trust. And he can't really explain to the court adequately why he made the change in January 2002 to apply a quarter each to the children's trusts of the capital and the income. So On all of those findings, His Honour decides that the husband did in fact have an intention to defeat the wife's claim, and he sets aside the 1998 instrument and sets aside the 2002 dispositions. So that leaves the trust, if I just pop back to here, that leaves us back in the situation that it was pre-1998, which means that the wife is a potential beneficiary of both the income and the capital, but Dr. Spry is not, and Dr. Spry is the one still in control. Now, Justice Strickland takes into account the assets of the trust into the pool, so the pool is about $10 million, and makes an order that the wife should have 48% of that. But specifically, Justice Strickland makes no orders requiring the husband to pay the wife from the trust assets. In fact, His Honour is at pains in the judgment to say it is a matter for the husband how he chooses to pay her. I think he ends up having to pay about $2 million because the wife already had about $2 million to her own name. So, Dr. Spry appeals and he is unsuccessful, but he obtains special leave to appeal to the High Court, and Mr. Kennon, who is the solicitor, who at this stage is the trustee of the Children's Trust, also obtains special leave to appeal to the High Court. And their arguments essentially amounted to this. The 1983 instrument, that was the one that was originally said to be irrevocable, was irrevocable. That's what they argue. They say the trust assets were not Dr. Spry's property, so because Dr. Spry was not a beneficiary, that was the effect of the 1983 variation, it couldn't be his property, and the trustee of the trust couldn't be compelled to add him back as a beneficiary.
So one has three different approaches from the High Court that we'll just pause to consider. As Leah's mentioned, the two variations in 1998 and 2002 are set aside. So in Justice Gummow and Haynes' approach, they are considering what rights the parties had, in particular the wife had, as a beneficiary in the trust, and that the way they describe it is traditionally that the intended beneficiary or the discretionary object has a right to the due administration of the trust, and that right or chosen action is in itself property. They say that one has to also consider that the husband had a fiduciary obligation as trustee. He could have appointed all of the assets in the trust to his wife, bearing in mind that he is at the pre-1998 trust. If we just go back to the helpful diagram, which I take no credit for. If we go back to pre-1998, he is no longer a potential beneficiary, but he is the trustee, and his wife and the children are the only beneficiaries. But at that time, according to the Gummow and Haynes approach, one considers his position as trustee and the wife's right to due administration of the trust. And they conclude the court could proceed as if the changes to the property rights brought about by the divorce had not occurred. And in effect, that is not a particularly controversial decision. It's a recognition of the trustee's powers and obligations and the right to due administration. So it's very much an approach based on the powers of the trustee and the powers in the trust document. It has very little to do with the way in which the trust was in fact administered over time and the way in which the parties had treated the assets, whether they were matrimonial assets or separately. The alternate approach of Chief Justice French perhaps has received more support since the judgment, and Justice French's approach is to consider what had been the husband and wife's interest in the assets of the trust prior to the 1998 amendments. And the approach is to effectively say, well, the assets that the trust had, namely their house and other property, had come from their efforts during their lifetime to build the assets. They were the product of the matrimonial relationship. The mere fact that they had been placed in a trust didn't change their character as property of the parties to the marriage. So the court could treat them as part of the pool. To put it another way, the husband had a discretionary power of distribution. He could distribute the assets to himself or the wife, or particularly the wife at that time. The rights and powers in the trust had a value equivalent to the value of the trust assets. And that's perhaps an important distinction between the approach of Justice French and that of Justices Gummow and Hayne. It doesn't simply see the interest in a trust of a beneficiary as no more than a chosen action or a right to be considered. But in the context of this trust, the only sensible consideration was to see the right to be considered and the powers exercised as equivalent to the trust, because an exercise of the trust's powers could only sensibly be to provide those assets to the wife during the marriage. Again, many of the commentators have said that it is an approach that focuses on the trustee's power, and that's a distinction that we'll come to when looking at some of the later cases. Another way to look at these judgments is to observe that all that Kennon and Spry really decides is the scope of the definition of property for the purposes of Section 79, and really no more than that in respect of discretionary trusts. And that when read together, the judgments of the majority comprising Justices Gummow, Hayne and French, is that for the trust's assets to be treated as the assets of the parties of the marriage for the purposes of a Section 79 distribution of assets within the pool, there are two criteria. First, that the parties to the marriage control the trust or have a power to appoint or distribute, so that they are the trustee, power to appoint the trustee, they may have de jure control of the trustee, and they have, by reason of that power of appointment or the power of the trustee, to be able to cause distributions. And secondly, the affirmation of the long-standing principle that the family court, in making adjustments of property rights under Section 79, because it is limited to the property of the parties to the marriage, one cannot affect or prejudice the interests of third parties. And that reaffirms the High Court's earlier decision in this context in 1981 in Ascot Investments, that says, in effect, except in the case of a sham, the court cannot ignore the third party's interests. And that has particular significance where the discretionary objects are broader than the husband, wife, and their children, which applies in many family trust situations. The third, and perhaps less commented on, at least judicially, judgment is the approach of Justice Kiefel, which was to consider an alternate route to dealing with the trust's assets. And it's one that potentially has broader application to a broader range of trusts. And that is to consider the trust's assets not under Section 79, but as nuptial settlements under Section 85A. Now that requires two things in this context. A settlement has been variously defined by other decisions of the full court in this context as a disposition of property. Now that could be either the creation of the trust, that could be a disposition of property, or the transfer of the property into the trust. And that is a controversial question in this context. And secondly, the definition of a nuptial settlement seems to introduce that the transfer or disposition of property is either consequential or incidental to the marriage. which is perhaps a relatively low bar. Importantly, in the context of Section 85A, it doesn't have the limitation that Section 79 has of not being able to impact the rights of third parties. So it potentially has application in relation to a broader range of trusts with a broader range of discretionary potential objects. Justice Kiefel argued, I think with some force, that the clear intent of Section 85A when introduced into legislation, as evidenced by the Joint Select Committee of Parliament that was involved, prepared a report in relation to this area, made it clear that the section was intended to apply to discretionary family trusts, and that settlement is a wider notion than property in Section 79A. Justices Gummow, Hayne and French expressly didn't deal with Section 85A. Justice Hayden, who wrote a dissenting judgment, took a different approach to Section 85A, both factually and as to the degree of connection. Justice Hayden in particular did not think it was possible to satisfy the nuptial connection on the particular facts of Kennon and Spry because the trust itself had been created 10 years before the marriage. And His Honour did not think you could treat each disposition of property into the trust as separate dispositions. He regarded the trust in itself as one trust and not able to be separated. This separate approach does not seem to have been commonly picked up in later cases, but perhaps it has some broader scope that people could consider in appropriate cases where there are a broader range of trustees.
And can only be used in cases where the parties were married because there's no equivalent de facto. So you need very specific factual scenario. So I'm going to go through two different cases that will sort of demonstrate what Kennon and Spry basically held. This first one is Ogden and Ogden. Essentially, this is one where the wife did not have control of the entire trust. The source of the trust assets were not, in fact, the labours of the marriage, but were her late grandmother's estate. And the beneficiaries to the trust included the wife and her 4 siblings, and their spouses and their children. So each sibling was an appointer, each was a director of the corporate trustee. On any measure, she did not have control. The wife did not have control of the trust in its totality. However, when having a look at the trust deed, the trust was actually divided into classes, and each of the siblings was an appointer for an individual class. And Her Honour Federal Magistrate Bender found that the wife did in fact have control of her class because she was the appointer for that class and she could make distributions to herself. So going back to what Justices Gummow and Haynes said, that essentially amounts to the trust assets, the amount that can be controlled by the wife, as being property of the wife. So Her Honour concluded that 20% of the trust fund was in fact property of the wife. Another example is in Mantle and Mantle, a more recent case. This is a slightly unusual one in the sense that the judge in this particular case, Justice McAvoy, came to an interesting decision. But again, the source of the trust assets was the husband's late father. There were 2 trusts in this case, a family trust and a testamentary trust. In relation to the family trust, the husband and his sister were joint trustees, but the husband, as the more senior trustee, had a casting vote in the event that they could not actually come to an agreement. And there was a fixed interest so that when the trust actually vested, the husband would receive 60%. So the wife's submissions to the court was 60% of the family trust should amount to the husband's property and it should be part of the pool. In relation to the testamentary trust, the husband was the sole trustee in relation to that, and the beneficiaries were the husband, the wife, and their descendants, and he had complete control over the testamentary trust. So again, the wife argued He's got complete control. He can make distributions. Therefore, 100% of the testamentary trust, those assets should amount to his property and should be counted in the pool. However, the husband actually gave very detailed evidence about what his late father's wishes were in administering the trusts. It's replicated in the judgment for a number of pages, and his late father talked about how there was a long-standing family tradition of supporting future generations in loaning them money for buying their own property. None of that very detailed evidence was in fact challenged in cross-examination, and the husband had given evidence which was accepted by Justice McAvoy that he would abide by his late father's wishes when administering the trust. So His Honour concluded that the family trust assets and the testamentary trust assets were not, in fact, property of the husband, but they were a financial resource because the husband was able to make distributions to himself. And in particular, His Honour found the fact that the assets of the trust were not the labours of either the husband and the wife, and neither party was saying that they had contributed to the assets, as being of some importance as to why it should be counted as a financial resource rather than property.
And in a sense, it's where we pause to make the observation that cases like, Mantle and Mantle, firstly, show the limits of Section 79 to family trust, because if we had been dealing with a strictly discretionary trust, so a trust that didn't have the specific designation of the 20% or a way to define the interests of the parties to the marriage and give them a defined value, if the trust assets were spread in an unclear or undefined way across a broader range of beneficiaries, you would not be able to say that it was property for the purposes of an adjustment. And Mantle and Mantle shows where the assets at that point move potentially from being assets in the pool to distributions. Now that has obviously practical difficulties in terms of bringing the assets before the powers of the court. So that is a real limitation as to what is currently decided. So it is unclear of the limits to which the court can make adjustments in respect of truly discretionary trusts or trusts that might be partly fixed, partly discretionary, where one inevitably cannot ascertain a precise proportion to a party to the marriage, where one still can say one is necessarily affecting third-party rights. It's unclear whether Section 85A can remedy that in the way that Justice Kiefel suggests. At the moment, there doesn't appear to have been cases that have picked up Her Honour's suggestion and run with it, given that it's effectively the view of Justice Kiefel, the opposing view of Justice Hayden, although on a narrower factual basis. And then the third sort of undecided question is the extent to which one can use the broad remedial powers, for example, under Section 114 of the Act to grant injunctions, and under the broader powers under Part 8AA, to require, for example, powers to be exercised by third parties. For example, to require a trustee or settlor to exercise a power under the trust, to either, for example, change the trustee or to make a distribution or to consider making a distribution, while still only adjusting the assets of the parties to the marriage. To what extent can one vary a trust's affairs without inappropriately affecting the rights of third parties? In this context, we get to what I think is an extreme example, which has a long history, which is a decision which initially goes to the full court in 2013 in called AC and VC. The parties were married for a long period. They had a trust with specified beneficiaries, but it was a discretionary trust. The vesting date was many, many years into the future. The husband and one of the husband's father were directors of a corporate trustee. When the husband resigned as a trustee, there was, for reasons that are not clear in the 500 paragraph long judgment, there was no appointer or settler or guardian of the trust after that time, which has peculiar significance. The way in which the judge approached this was to find that the trust assets, or that the beneficiaries of the trust, had what is described by Justice Crisford as a fixed and irrevocable entitlement to a share of capital upon a vesting of the trust. It is far from obvious how one can reach that conclusion in respect of a purely discretionary trust. What the judge did, and this was the issue on appeal, was ordered that the trustee bring forward the vesting date to the date of trial in effect, and that would have the effect of distributing all of the trust assets to the beneficiary and effectively bring all of the trust assets into the pool other than an allocate proportion for the husband's mother, who was then 85. Now, in affirming that decision, the full court said it was a most unusual case because one could reach the conclusion of a fixed and irrevocable entitlement purely because of the absence of an appointer or guardian. Now, it's perhaps significant that that factual finding in relation to the trust wasn't challenged. It seems a situation that would be very difficult to replicate factually. Ordinarily, it's difficult to imagine circumstances where a discretionary trust of the kind described there could be said to create a fixed and definite or irrevocable entitlement to particular portions of the capital in the trust. Ordinarily, one would anticipate that the only interests of the beneficiaries is a right to be considered in the usual discretionary way and the due administration of the trust. So it is difficult to see how one can use an authority like this and seek relief requiring the vesting date to be brought forward to, in effect, bring the trust to an end, to bring all of the assets into the pool. And it perhaps raises a question about what one can do, and this perhaps raises the question about the longer history of this litigation.
As Ed's already alluded to, so when this went on appeal to the full court, a number of different parties ended up appealing. The husband's mother appealed in her own capacity. She was taking about $2,500 to $3,000 a month in living expenses, which Justice Crisford said, well, based on your age and your life expectancy, I'm going to round that up to about $338,000. That's how that number was calculated. She was also the director of the corporate trustee, so she, in that capacity, appealed, as did the corporate trustee and the other director. And the husband's sister, who was a general beneficiary of the trust, appealed as well. So although the husband was a specified beneficiary, the husband's sister was a general beneficiary who argued that by bringing forward the vesting date, she would lose out in her ability to be considered for distributions of income of the trust. And the Commonwealth Attorney General intervened in relation to some constitutional questions. So the full court certainly affirmed that the court had the power to bring forward the vesting date. provided that the matters listed in 90AE and 90AF were met. Now, jogging your memory, those are things like third parties need to have procedural fairness, the court, they need to be able to be heard on the matter, and the court has to consider tax consequences and a number of other different things. Now, it's not immediately obvious from the name of this case being AC and VC that this is actually Charistia. I'm not sure I'm pronouncing that correctly. But this is the famous case that's only just gone to the High Court. So you know what the background was. Justice Crisford reached a conclusion that was the orders that were made were found to be valid orders, but procedural fairness hadn't been afforded. And so the full court upheld the appeal on those grounds. But bizarrely didn't end up remitting the matter for rehearing or re-exercising discretion. So the husband and the wife actually disagreed as to what should happen next in the proceedings, and there'd effectively been no decision about what would happen with the trust. So Justice Walters decided that Justice Crisford's decision was interlocutory, and His Honour ended up making a final determination, but as you might well know, that was done in the context of having some communications with counsel, which the High Court quite appropriately said was an inappropriate thing to do in that context. His Honour's now retired, and so the matter's actually been remitted. So it's a sort of watch this space. We don't know what the Family Court of Western Australia will do, but clearly the full court in this matter confirmed that the court had the power to bring forward the vesting date. So some practical tips. Sounds very obvious, but obviously you're going to need a copy of the trust deed, and you're going to need a copy of any amendments that have been made, including secret amendments by various parties. If there's a corporate trustee, you might want to get a copy of the constitution to see how the corporation can be managed. You should absolutely be doing a company search on the corporate trustee to identify the directors and shareholders. Remember, you're going to be trying to work out who's got control of this trust. So who is a director and shareholder of the corporate trustee is going to be relevant to that question. You have to read the trust deed carefully. I know we say it so frequently in family law that every case turns on its own facts, and in this area in particular, every trust case turns on its own terms of the trust deed. So read the trust deed very carefully and identify who has the power to remove and appoint the trustee. Work out who are the beneficiaries or potential beneficiaries. Work out, is it actually a discretionary trust or a fixed trust? And have a look at the powers of the trustee. We also recommend that you get a copy of the financial statements of the trust and the tax returns of the trust to see how distributions have historically been made, and some correspondence about how the trust was established, used, and controlled. So a good example of this would be who's got access to the bank accounts. If the husband's father is the person that is actually the trustee, but the husband is the one that has access to the bank accounts and is making the transfers to his own bank account, then there'd be an argument that he's really the one with control. Who's emailing the accountant to make distributions or recommendations about various different things? Who was emailing the solicitor to get the trust deed drafted? So you'd be looking for those kind of documents, and in relation to trust administration, back to that Mantle and Mantle case, are there any documents which show how the trust is usually administered? So if it's a corporate trustee, are there meeting minutes, for example, of the family setting out what they want to use the trust assets for? Those would all be relevant to really who has control of the trust and how is it being used in the past. You also want to get instructions on the source of the trust assets. So as in Kennon and Spry, where it was really the labours of the parties to the marriage, as opposed to in Mantle and Ogden, where the source of funds came from somewhere else, you'll want to be finding out who made the significant contributions to those trust assets. Some of these things, by the way, you might end up having to subpoena, but you want to be careful Obviously, you can't go on a fishing expedition when you are searching for particular documents. So if you end up having to subpoena documents, if you're acting for the husband, for example, and it turns out that the wife is a beneficiary of a trust, she might not actually be entitled to copies of various documents. You might end up having to subpoena the trustee, if it's a corporate trustee, for example. You want to have some good evidence in your affidavit about what the husband understands had happened during the marriage about distributions for the trust. Remember, when you're looking at subpoenas, this is not a court of pleadings usually, so the court will be looking at the affidavits to see what the real issues are, and if your clients want an affidavit to say, my wife was regularly receiving $20,000 distributions every year from the trust, and we received holidays, we were living in a house rent-free for a while, that will likely form a strong basis for why those documents will be relevant and why the husband has got a real argument as to whether the trust assets might be property or at least a financial resource.
I suppose one should always remember that a little bit of light fishing is okay, but one should never trawl. Trawling is generally bad. And in this context, where third parties are involved, the court has been known to require pleadings or points of claim in this context to permit the identification of the way in which the trust claims are advanced. We've set out, hopefully, the obvious propositions of pleadings. I suppose the most obvious proposition is one should immediately brief junior counsel to draft the pleading. But if one does it oneself, the important things to remember is one pleads facts. One fact per paragraph. One does not plead evidence, and one does not include submissions or conclusions of law, although they are sometimes helpful for articulating the way in which the case is put, but they're not essential in a pleading. One never pleads conversations with quotation marks or quotes documents. One pleads the effect of conversations or documents, and obviously, where appropriate, one pleads foreign law. In this context, there seems to be a flurry of what one would see as ordinary litigation, summary judgment, and similar applications. They tend to have limited success and are only really useful in the clearest of cases. One also sees situations of parties seeking to have separate hearings on separate questions. On the trust questions, one sees them refused in 99% of the judgments I've read where someone has sought separate questions on the trust questions, usually because there are common questions on both. The other thing that seems to be very common once one raises these sorts of trust third-party issues is there seem to be a whole series of transfer applications that are regularly made. The only observation we would really make at the end, and it's really a closing one, is in almost every case, and it's summarised quite pithily by Justice Brereton, that ordinarily, because the whole dispute can be filed in the family court and the family court can deal with all issues, it's generally better if all of it goes to the family court. So generally, bringing a separate trust or proprietary claim by other family members in the Supreme Court to try and have them dealt with by different judges seems to be a fraught and pointless failure.
So in that, I would say that if you're acting for a third party, so if you're acting for the husband's brother who is a trustee or beneficiary under a particular trust, you'll want to think very carefully about whether or not you commence in the Supreme Court, because you're likely to be faced with a transfer application if family court proceedings are still on or already on foot. And also, the issue is your client really going to be engaged in what could be lengthy and protracted family law proceedings in circumstances where there are, of course, presumptions about what happens with costs for parties to family law proceedings.
Which I think drives so many of the applications for separate questions, which seem to go nowhere. There is often no way out of being stuck in these sorts of cases. But that is
settle. That's the way out.
They are inevitably complex and dry and document heavy, but they tend to find the pots of gold hidden under mountains and mountains of rainbows. So they certainly can be useful depending on which side of the bar table one is sitting. So thank you all for your
Thanks for watching
this afternoon. I don't know if we have any questions, assuming everyone's still awake. It is a dry topic, so we've tried to keep it remotely on point. So thank you to everyone for your attendance and acquiring of another CPD point.